right, it's just a little bit after 9, so let's go ahead and get started. We are still admitting a few folks from the waiting room, and that's great. We're glad to see so many people interested in this program. My name is Laura Vermillion, and I'm the president of the Blue Springs Chamber of Commerce. And today we're here to talk about the Corporate Transparency Act. We are recording this presentation. We had several people who could not attend today's session, but they still wanted to receive information about this program. So we're going to be sending the recording to everybody that registered. You'll get that most likely tomorrow. So for those that are listening to this recording at a later date, and for all of you that are on the call today, we do want to let you know that everything that is being presented is accurate as of today's date, which is January 18th, 2024. Becca Blake from my staff is on the call. She's going to be monitoring the chat today. There's Becca. And so if you have questions as the presentation is moving along, please go ahead and put them in the chat, because she's going to be filtering through those, and then we'll do a question and answer session after the presentation. We are really glad that we have all of you on this call today. This is a joint presentation by multiple chambers of commerce, which is really exciting, and Square One, which is a program of Mid-Continent Public Library. So I just want to recognize all of the co-sponsoring chambers. I know that we have staff members as well as chambers, chamber staff members and chamber members on this call from varying chambers. So we have the Gladstone Chamber of Commerce, the Grandview Chamber of Commerce, the Green Valley Partnership, the Independence Chamber of Commerce, the Kearney Chamber of Commerce, Parkville Chamber of Commerce, Platte City Area Chamber of Commerce, the Smithville Area Chamber of Commerce, the Raytown Area Chamber of Commerce and Tourism, and of course, the Blue Springs Chamber of Commerce. We also, though, have some chamber executives from other chambers in the state who are on the call just to get information for their membership. I know we have the Cape Girardeau Chamber, the Moberly Chamber, the Dexter Chamber, and then also representatives from the Missouri Chamber of Commerce. So I'd like to offer all of you a special welcome. All of our chamber friends throughout the state, we're really glad you're here. Next, I'm going to turn this over to Ashley Muffett with Square One, and she's going to introduce today's speaker. So Ashley. Ashley, are you there?
Okay, there we go. I can't unmute myself, so okay, sorry. I have a lot to say. I'll make it quick. Hi, I'm Ashley Muffett with Square One. Thank you so much, Laura, for that welcome and that introduction. Also, huge shout out to Polsinelli and Bill Quick. He was one that came out with a bunch of information and put himself out there as a target for us to reach to when we started getting questions from the business community about how they can report and comply for today's presentation. So I really appreciate it. I'm excited to be a part of it. I'm new here with Square One. We offer business services and career services as part of the Kauffman Foundation grant funds, as well as property tax that supports our Mid-Continent Public Library system. So we're here to support you in all of your business needs. We do that through a very couple different paths. We have our one-to-one counseling that you can book with our business services, our social media services, or if you happen to be seeking careers, we also offer career services one-to-one support. And then we have programming that we try to bring to you like this and others, workshops and classes that help you start and grow your small business. We like to focus on that Square One and being able to have a safe place to test ideas, whether that's a business idea or ideas within your business. So I really appreciate the opportunity to get to be here today. And then for our presentation, we reached out to Bill. He's with Polsinelli. Bill, I pulled your bio. I highlighted a couple things, but you have a ton of accolades here. So forgive me if I get anything wrong or miss anything. But some things that I think are important to this is being a part of the American Bar Association, specifically on corporate laws and corporate governance, being a part of the Kansas Bar Association, past governor, board of governors there, authoring a book on Kansas, or not a book, a handbook, excuse me, on Kansas limited liability companies in 2021, And I could go on, but Bill, I really appreciate you joining us today and providing us so much information. I know there's going to be a ton of questions, so I'm going to, with that, sign out. Or, well, go on mute.
Well, great. Thank you, Ashley, for that great introduction. Thank you, Laura, for helping to put all this together. You know, chambers of commerce and libraries are the glue that binds our communities together and makes everything operate in a great way on a community basis. So I really appreciate the opportunity to be here today and to speak to your groups. I'm going to turn my slideshow on now, I think. Good. Is everybody able to see the slides?
Yes.
Yep, we can see them.
Okay, great. So in the lower right corner, I've got my email address, which is easy to say, hard to spell, wquick@polsinelli.com. And then also my LinkedIn, which is William Quick. Feel free to connect with me if you would like. Feel free to send me emails if you have questions at the end of the program. So we're here today to talk about the Corporate Transparency Act. It is a sleeper law. It's been around for 3 years. Many have not heard about it. If we were doing this a month ago, I'd say almost nobody has heard about it, even though it went into effect on January 1st. So it's been up and running for 18 days now. But most people may or may not have heard about it. Most people don't know what the impact is. And there's a lot of misinformation circulating, including the usual parade of scam artists trying to bilk money out of people. So what I'm here today to do is to let you know this is a thing. It's real. It's happening now, and what you need to be aware of and what you need to do about it. I will say if you get any kind of correspondence and there's a QR code on it, do not access the QR code. Be careful about accessing any links on emails. The Financial Crimes Enforcement Network of the U.S. Department of Treasury is in charge of the Corporate Transparency Act. They've got a fraud warning on their website. There is no charge for the Corporate Transparency Act. So if anyone is saying to send them money to pay a filing fee, that is not a thing. So I will start with that word of warning. So what's the Corporate Transparency Act about? So the Corporate Transparency Act is designed to help combat the use of shell companies in the commission of illicit activity and corrupt practices, as well as to protect national security. So the objective of the Corporate Transparency Act is to cause companies in the U.S. that aren't already providing information about their beneficial owners to start providing information about their beneficial owners so that oligarchs, despots, terrorist organizations, other nefarious parties can't hide their money in the U.S. through the use of shell companies or other types of business entities that shield the identity of their beneficial owners. So as I mentioned, it's been around for 3 years. It passed Congress and was enacted into law over then President Trump's veto. So a supermajority of a conservative House and a supermajority of a conservative Senate passed this into law over a veto on January 1st, 2021. It went into effect January 1st of 2024, so a couple of weeks ago, and it is up and running. So what does the Corporate Transparency Act apply to? So the Corporate Transparency Act applies to any entity that is formed through a filing at a Secretary of State's office or an equivalent tribal office in the U.S. This also includes territories of the U.S. And it also includes any non-U.S. business entity that qualifies to do business in the U.S. through a filing with the Secretary of State's office or a tribal office. Everything that I'm going to talk about today applies to tribal offices and tribal lands. I'm not going to repeat that, but it is there. So if that applies to you, just know that this all continues to apply to tribal authority. So the CTA requires certain businesses, and these include privately held and nonprofit entities, to report direct and indirect human beneficial ownership, control, and some service provider information to the Financial Crimes Enforcement Network of the U.S. Department of Treasury, and that is known as FinCEN. FinCEN has stood up a portal and a system. It's called the Beneficial Ownership Secure System, BOSS system, to receive the information that we're going to talk about. If FinCEN doesn't go out and get Bruce Springsteen as a sponsor of their program, I think they're really missing the boat. But they've set up this system to receive this information. And one of the key parts of what I've just said is this includes indirect human ownership. So if you have a situation where you have a business entity that's owned by a business entity that's owned by a business entity, you have to look through all of those business entities to the human beings involved. And if they meet the criteria for disclosure, you have to disclose personal identifying information, PII, of that human being. So that's what all of this is about, is reporting personal information about the human beings that are behind business entities in the US. So traditionally, in I guess still to the day, the states have had the purview for the formation of business entities. So typically, if you're going to form a business entity, you form it at the state level, and it's governed by state law. So this is the first time that the federal government has stepped in to the ownership and control of business entities on a federal level, that for entities that have not affirmatively taken a step to be governed by federal law. So obviously, public reporting companies have been disclosing their information to the government. Banks and credit unions and insurance providers have been providing their information to the government for a long time. But all of those parties chose to have their information disclosed because they wanted the benefits associated with that status. This is the first time that everyone, including people that do not want to have their information disclosed at the federal government, are compelled to do that. So this is a fundamentally new and different thing that we haven't seen before in corporate law in the US. So FinCEN has estimated that there are going to be 32.6 million business entities, 32.6 million business entities that are going to have to report in the first year of reporting, which is right now. They also have estimated that there are going to be 5 million new business entities formed every year going forward that are also going to have to report under this law. So you can see that the vast majority of businesses are going to have to report under this law. Nobody wants to report under this law. When you talk to anybody, they see what they want to see in the information, and they think they have an exemption. Everybody thinks they have an exemption, but the reality is almost no one has an exemption. And we're going to get into the exemptions here in a second, but I just want to make that clear. Almost nobody is going to have an exemption. So if you have a dream and a hope, unfortunately, I'm going to quash that today. I've talked to numerous people about this. A lot of times I'll get brushed back from small business owners, and they'll say something to the effect of this: "Oh, we're a small business. That's for the big boys. It's not going to impact me." That is the exact opposite of what the reality is. The small nature of the business is exactly why this applies to people. This is the federal government trying to get information on small operating companies that otherwise have flown under the radar. And as I've said in some of the materials I've put together, FinCEN is casting a very broad dragnet, and there's a ton of bycatch. and they're really spearfishing for select few people. But the vast majority of the U.S. business community is going to get swept into this and have to deal with it. So I've told you who the Corporate Transparency Act applies to. It applies to anyone who has a business entity that is formed through a Secretary of State's filing. So if you meet that criteria, you are subject to the Corporate Transparency Act. And the whole purpose of the Corporate Transparency Act is to get you to report your beneficial ownership information. There are 23 exemptions to the reporting obligations that will exclude you from the requirement to report. If you don't have an exemption, then you will have to report. So the categories of exemptions, I kind of fit into a couple camps. 20 of the 23 exemptions are basically this. Hey, we're already a heavily regulated business. We have to disclose a bunch of public information already. It would be duplicative for us to have to report under the Corporate Transparency Act. So those would be on the slide that I've got pulled up, it's kind of the third box down. Those would be parties such as public reporting companies, registered broker-dealers, utilities, financial institutions like banks or credit unions, or money service businesses, which would be like a PayPal type of a institution, insurance providers and insurance companies. So if you were regulated by the insurance commissioner, you are going to be exempt. If you are part of affiliated businesses to an insurance provider and you don't have to report to the insurance commissioner, you aren't going to be exempt. So it's only the ones that are reporting information to the insurance commissioner. Commodities exchanges would be exempt. CPA firms, if they are registered under the Sarbanes-Oxley Act, are exempt. Any other CPAs that don't meet that criteria are not exempt. Certain pooled investment funds are going to be exempt. Basically, those are the ones that are administered by a registered broker-dealer who has, filed with the SEC. A lot of people will say, oh, well, pooled investment vehicles are excluded, so that's us. You need to check and confirm that you are part of the defined pooled investment vehicles that are excluded, because the vast majority of pooled investment funds are not excluded. If you have a 501c recognized federally tax exempt nonprofit, you will be exempt. If you are exempt under any other part of the Internal Revenue Code, you are not exempt. Only 501c. So that would be like 501c3s, which are kind of the charitable nonprofits we're used to hearing. 501c4s, which would be like the Chamber of Commerce. 501c6, which would be political action groups. They're all going to be exempt. Also, I believe churches fall under 501c, even if they don't make an affirmative filing. I think they're covered under 501c, so they would be exempt. But if you have something like a homes association that's a nonprofit business, but they have never filed for a 501c designation, they are not going to be exempt. They're going to have to report. There are a lot of nonprofit organizations out and about that have not filed for 501c status, and as such, they are going to be obligated to comply and report under the Corporate Transparency Act. Governmental and quasi-governmental bodies are going to be exempt under the Corporate Transparency Act. So there are 3 exemptions that remain after that. One exemption is if you are a subsidiary of certain, but not necessarily all of these exempt categories that I've rattled off. If you're a wholly owned subsidiary, you get to share in your parent company's exemption. Also, if you are a quote inactive company, then you do not have to report. But as with everything under the Corporate Transparency Act, there's the definition involved. So in order to be an inactive entity, among other things, you have to have been formed before January 1st, 2020, and you have to have had no activity and no economic activity with that organization for 12 months. If that fits you, then you may be able to avail yourself of the inactive entity exemption. But if you were formed after January 1st, 2020, or you've had any activity in your business in the last 12 months, then you are going to have to report. This gets a little bit crazy when I say the next thing. So FinCEN has indicated that if you have an administratively dissolved business, so you defaulted on making your annual report to a Secretary of State and they have revoked your charter and you are administratively dissolved, you would still have to report that entity under the Corporate Transparency Act. The only way you get out of that reporting is to have formally terminated that business entity with the Secretary of State. I did a presentation with the Kansas Secretary of State in December, and they, as part of their presentation, was talking about all of the entities in their system. They have over 5 million administratively dissolved entities in their database. That's just Kansas. So that is a huge sleeper issue that people aren't aware of. So I saved the best for last. So the last exemption is called the large operating entity or large operating company exemption. That is the exemption that all businesses can either fit within or not fit within. So you don't have to be a regulated business. You don't have to meet some other criteria. If you can meet this threshold, then you will be exempt. So the large operating entity exemption requires that you meet a 3-part test. You have to meet all 3 parts of the test. So the first part is you have to own or lease commercial real property where you operate your business. So that would have to be either a deed or a lease or a sublease of commercial property, not your home, not your garage, not your basement. It can't be WeWorks or Regis office sharing situation. Can't be mailboxes, etc. It can't be your attorney's office. It can't be your registered agent's office. It has to be the leased or owned by the specific business entity that you are looking at to make that filing. So one of the aspects of the Corporate Transparency Act is every single business entity has to make its own determination as to whether it is exempt or reporting. And then if it's reporting, has to report its own information. So you don't get the benefit of affiliated parties. You don't get the benefit of parents or subsidiaries other than the exemption I told you. If you have an exempt parent that wholly owns a subsidiary, the subsidiary will be exempt. Otherwise, you don't get attribution parent or subsidiary with limited exceptions. So you have to have a physical street address. Second, you have to have 21 or more full-time employees of that business entity, not of an affiliated entity, but of that business entity. That has to be full-time employees, 30 hours a week, 130 hours a month. It can't be part-time. It can't be leased employees. It can't be independent contractors. It's not full-time equivalent. It's full-time employees that are getting a W-2 that has that company's name on it. The third part of the test, you have to meet all 3 parts. The third part of the test is you have to have generated more than, so over $5 million of US generated revenue or gross sales as reported on a prior year's federal tax filing. So right now, that means you have to have a 2022 tax filing that shows that you had over $5 million gross receipts generated from US sources. If you meet all 3 parts of that, then you would be exempt under that large operating company exemption. Also, if you have any subsidiaries under an entity that has that large operating company exemption, they would also be exempt under the subsidiary exemption. So what invariably happens is I'm talking to people like they have a portfolio of companies. They've got multiple companies that they own. And they'll look at this and like, oh, well, that's great. We've got over 21 employees. We got over $5 million. We've got a street address. We're fine. We're exempt. And then you actually start to drill down with them, and they realize, well, okay, all of our employees are actually in a management company or an employee company that is a subsidiary of a holding company, because we've consolidated all our employees in one business entity to help manage the flow of salary and compensation, to isolate the liability exposure of having employees, et cetera. A lot of business decisions, caused us to put all of our employees in one entity, and it's a subsidiary of the holding company. And then you have a holding company, and then it has a bunch of other subsidiaries, and they may be wholly owned or not. But what happens is, because all the employees are in that subsidiary, only that subsidiary would be able to get the large operating entity exemption, and none of the other entities in their portfolio would be able to enjoy that. If the holding company has all of the employees and has the revenue and has the street address, then the benefit can trickle down to wholly owned subsidiaries, but not partially owned subsidiaries, but it doesn't flow upstream. Also, on the $5 million threshold, if you have a corporate tax structure and you file a consolidated tax return, all of the corporations that are party to that consolidated tax return can use the attribution of the $5 million, not just a holding company, but any of the companies in that consolidated group can use the $5 million. But they can't use the employee count. Employee count cannot travel to affiliated parties, upstream, downstream, sideways, any other way. So, with this flow chart, you kind of go through the pachinko machine, and you get down here to the bottom, and you're like, well, am I a reporting company or not? So if you're a sole proprietor, you're good old fashioned estate planning trust, you're a general partnership that you didn't file anything with the Secretary of State, boom, you're exempt. You don't have to worry about this. You're not exempt. The statute doesn't apply to you. If you're a corporation, you're a limited liability company, a limited partnership, a statutory trust, and certain other permutations. If you have formed your entity through a Secretary of State's filing, then the act applies to you. You have to then go down and you have to look at the exemptions. If an exemption applies, then you don't have to do anything. You don't have to report. Exemptions are self-executing. So it's kind of like the blue sky law. If you don't have to comply, you don't have to comply. There's nothing you have to do. You just go about your merry way. My recommendation is, if you are exempt, you should have something that you put in your records that shows that on this date you did an analysis and you affirmatively determined that you were exempt from the Corporate Transparency Act, and which exemption and why, and have that in your file. So if you ever get called to task on that issue, you have something to go back and rely on. But you don't have to file anything with the government to be exempt. If you're exempt, you're exempt. If you're not exempt and you fit within the criteria of the act, then you will be a reporting company. And that's kind of the meat and potatoes of this whole thing, is reporting companies, and then reporting companies disclosing personal identifying information about their beneficial owners. So beneficial owner is a defined term under the act, as with all these things. So the beneficial owner, there are two different ways you could be a beneficial owner. One way is if you have substantial control over a reporting company, you're a beneficial owner, your information has to be disclosed. That has nothing to do with ownership. So calling it a beneficial owner is kind of a misnomer, because it has nothing to do with ownership. The second way you could be a beneficial owner is if you have 25% or more ownership of any tranche or class or division of equitable ownership or economic ownership in the company. So if you have a company with preferred stock and common stock and a couple different categories, each of those classes of stock, you have to go and do an analysis of who has 25% or more ownership, and those people will have to be disclosed as beneficial owners. If you have a partnership taxed entity and you've got an economic waterfall and it's kind of complicated and different members have different economic rights, each of those classifications of economic rights will require you to make an independent analysis of who has 25% or more ownership. So for example, if you have a carried interest or a promote, that's going to be separate from the other member ownership. And if someone has 25% or more of that carried interest or of that promote interest, they would have to be disclosed, as well as people that have put money in and have a capital economic interest. The the economic ownership also takes into account any options, warrants, puts, calls, phantom ownership interests, any kind of synthetic equity. If you have convertible rights, that also has to be factored in. You have to treat it as though the convertible right has been exercised on the date that you're making the analysis, and that all of the shares could be and are exercised. So even if you have like stock options that are vastly underwater and no one in their right mind would ever exercise those stock options, if the stock options are still outstanding, you have to factor those into your analysis. So with the beneficial ownership, this is the part of the whole deal that's going to require a very facts and circumstances determinative analysis. And you're going to have to use business judgment to determine who are beneficial owners and who are not beneficial owners. That's probably the place where you will want to get your attorney involved to help you. If you have a very simple structure where it's, 2 owners, 1 class of stock, not going to be very difficult to file this. If you have a complicated real estate transaction where you've got multiple members of a LLC and they all have different economic rights, and you've got some people with a carried interest, and you've got some options and other things, that could get very complicated. You're gonna have to sit down and do a reasoned analysis to make the determination of who's a beneficial owner in that context. So I'm gonna jump back to when I talked about substantial control. So substantial control is any meaningful control of the business. So FinCEN has said in their rules that they've promulgated, there are certain things that are just out of the chute going to have substantial control. But there are other things that are going to be amorphous, and you're going to, again, have to do a facts and circumstances determination, use your business judgment, and figure out who needs to be reported. So the easy things are, if you're a corporation or other business and you have senior officers, a senior officer is always going to have substantial control. So that would be someone like a president or a vice president. Or if you have the word chief in front of your officer title, if you are a CEO, CFO, COO, all of those people are going to have substantial control and are going to have to be disclosed and have their personal identifying information disclosed to FinCEN. If you have an in-house attorney with that company, that in-house attorney, by definition, from FinCEN is going to have to be disclosed as a substantial control party, even if they don't have any actual authority. If you are a manager of a manager-managed LLC, if you are a member of any member, even if you only have a very small ownership, any member of a member-managed LLC will have to be disclosed because you have apparent authority to act on behalf of the entity. If you're a general partner of a limited partnership, you will have substantial control. If you are the trustee of a statutory trust, a trust that's created through a filing at a Secretary of State's office, that trustee will have substantial control. If you have a trust that owns a reporting company, and that trust has the ability to appoint a majority of the board of directors or to appoint someone like a manager with authority, then that trustee of the trust will have substantial control and is going to have to be disclosed. Substantial control, just like ownership, is direct or indirect. So if you have kind of a complicated organizational structure where you have multiple levels of entities, you may have to go up multiple entities in that ownership chain to determine who has substantial control. If you have a person who's a manager of a parent entity who controls a mezzanine entity, who controls a subsidiary property level entity, that manager at the 2 steps up parent entity would have to be disclosed as having substantial control. They would have to have their PII disclosed. One other thing. So for all business entities, you have to disclose the beneficial owners. If you have a business entity that's formed on or after January 1st of 2024, there's also a party called a company applicant, and that's the person who serves as the organizer or incorporator or other equivalent person whose name appears on the formation filing. That person's personal information is going to have to be disclosed as well. And if that person directs someone else to do the actual filing on their behalf, you also have to disclose that other human being's information. So that could be someone at, a law firm or a third-party service provider may have to have their personal information disclosed as well. So what's this PII that you have to disclose? So the PII is you would have your full legal name, your date of birth, your current residential street address, and here's the part everybody loves, you have to submit an image of a unexpired US passport or an unexpired driver's license issued by a state or tribal authority, or an equivalent state-issued ID card that has both your photo on it and a government-issued ID number. So you have to have all of that information to report into the system. That's your PII. So if you're a beneficial owner, either through economic ownership or through substantial control, you would have that information reported to FinCEN. So because you've been a good audience, I'm going to share with you a cheat code. So there is a cheat code involved in the Corporate Transparency Act. It's called a FinCEN identifier number. So you as a human being can file with FinCEN the same information I just rattled off, those 4 things, and FinCEN will issue you what's called a FinCEN identifier number. And it's equivalent to what would be like a known traveler number with the TSA. So it's a number that's issued only to you. It will continue on with you for your rest of your life, and that's your number. Anytime you would have to disclose to someone your personal identifying information for purposes of the Corporate Transparency Act, you could instead give them your name and your FinCEN ID number. I am recommending, advising, demanding, requiring every person that is my client, have your people get FinCEN ID numbers. I went ahead, I got mine on January 1st. It did not take a lot of time. It was fairly painless other than having to have my photo in this database. It was easy for me to get. So the benefit for me is I don't have to give out my date of birth. I don't have to give out my residential street address. I don't have to give out my passport image to third parties. If they need it from me, I can just give them the FinCEN ID number. The benefit to the company is they can just report that number. They don't have to type in all this information for me, and they don't have to be responsible for keeping that information updated in FinCEN's database. Either way, once your information's in the FinCEN database, it has to be maintained as current. So if you have any event that causes the information in that disclosure to change, you have 30 days to report that to FinCEN. If I have a FinCEN ID number, this is just an issue between FinCEN and me. If this list of information is used by a company rather than my FinCEN ID number, then that company is legally obligated, required, liable for keeping that information up to date within 30 days of any change event. Not within 30 days of when the company becomes aware of the change event, but 30 days from the change event. So if Bill, on a whim, decides he wants to change his name, or Bill decides he likes his neighbor's house better than his house, and we swap houses, and the number on my address changes by 1 digit, or my passport expires and I have to get a new passport. All of those things are going to require an update with FinCEN. If I've got a FinCEN identifier, then it's up to me to get that information to FinCEN. And if I don't meet it, get it in 30 days, I'm going to get fined. If instead I've given my personal identifying information out to 5, 10, 100 companies, I am required by the law to tell those companies when my information changes, and they are required within 30 days of the change event to file that updated information with FinCEN. So you can see it becomes very cumbersome to have that personal identifying information held and used by the companies themselves. Also, they have to maintain that personal information in their record system, and most people don't want their personal information floating around. So there are a lot of advantages to using the FinCEN identifier number. That is my recommendation. So when's this filing due? So if you have a business entity that was in existence on or before January 1st, 2024, you have 1 full year to make your initial filing. So that means you have until January 1st, 2025 to make your initial filing. If you have formed a new entity on or after January 1st of 2024, you have 90 days from the date of formation to make your initial filing with FinCEN. Once we get into January 1st of 2025, that 90 days gets reduced to 30 days. So starting January 1st of 2025 to the indefinite future, you will have 30 days from the date of formation of a new business entity to get the information reported to FinCEN. So you're asking yourself, well, what's the big deal? What if I don't do this? So there are civil and criminal penalties associated with the filing obligations to FinCEN. The civil penalties are $500 per day, up to $10,000 per violation. There are criminal penalties of up to 2 years imprisonment in federal prison, but that is only if you have willful misconduct or evasion. So most people don't, I wouldn't worry about that, but it's out there. So that is going to be used more for nefarious companies that are, terrorist groups, oligarchs, etc. Sanctioned parties that you can't deal with parties in the U.S. So the civil penalties, can be fairly substantial. Once you have made your initial report with FinCEN, you have to keep it up to date. So any amendment that you miss could rack up to $10,000 fines. There is no periodic reporting aspect of this. So whenever a change event happens, you have to report. If you file your initial CTA report and you don't have a change event, you never have to file with FinCEN again. But if you have a situation where you have some frequent changes, you're hiring new people that have authority, you're firing people that had authority, you are changing your ownership structure, any of those things could trigger a filing requirement with FinCEN. So it's conceivable that you could have 350 filings a year with FinCEN if you were active enough. But you might also have 0 filings. It's going to be up to the exigencies of your business operations. So I've got some considerations here that you can look at while we're taking questions and answers. The one other thing maybe there's 2 other things. So one other thing that I would tell you is this information is going into a super secure federal repository, and the only people that can access this information are federal law enforcement, federal agencies through their enforcement activities, state, local, and tribal law enforcement if they have a court order, or certain foreign law enforcement agencies if they have the appropriate, treaties, et cetera, with the U.S. and have the appropriate credentials to get this information. In addition to that, any financial institution can get the consent of its customer to access its information in the BOSS database. So what I think is going to happen, and it hasn't happened yet, FinCEN is still in the rulemaking phase of their access rule. I believe that what's going to happen is FinCEN is going to effectively deputize the banking system to be the people that, marshal people to compliance with this act. So what I think is going to happen is probably later this year, we're all going to get something from our bank that says, hey, you need to give me consent to access your information in the BOSS system. And if you don't, I'm going to close your bank account. Or if you don't, I'm not going to extend your loan. I'm not going to renew your loan. I think that's going to be one of the effective enforcement mechanisms associated with this act to make sure that people comply. I will also say I sat through a online talk with the IRS's chief enforcement officer last summer. And the person who was interviewing them specifically asked, hey, what are your views on, what are you going to do with the FinCEN database that they're doing under the Corporate Transparency Act? And the chief enforcement officer for the IRS said, hey, we got $80 million, I think. So they got, maybe it was more than that, $80 billion. I can't remember what the number was. They got some large amount of money. They're like, we're going to go on a hiring spree. We're hiring 80,000 new employees. A lot of, a third of those are going to be agents. A third of those are going to be data analysts. And we intend to have a data analytics driven approach to our audit selection and our criminal enforcement activities going forward. And we intend to use the FinCEN database to help with that process. So the IRS intends to use this. The IRS is also, FinCEN and the IRS are both under the U.S. Department of Treasury. So that didn't take a huge leap to figure out that was going to happen, but they have affirmatively stated that that's their intent. So you can take that to the bank literally and sign your, BOSS consent. Hasn't happened yet, but I think it's going to happen later this year. So one other thing I'm going to tell you, and it may not impact people in the KC Metro as much, but New York State has just at the end of December passed what's called a New York Limited Liability Company Transparency Act. And it is kind of modeled after the Corporate Transparency Act, but it only applies to limited liability companies, but it applies to every limited liability company that is formed in New York or that is qualified to do business in New York. And it will require this same beneficial ownership information to be reported to the New York Department of State. And there is no 25% threshold. If you own any interest in that limited liability company, you will have to be disclosed as a beneficial owner. So that's coming down. That's going to happen. California also had a similar but different transparent, business entity transparency act that they had go through their legislature this past term. It did not get passed out of the legislature, but I understand that it is going to get reintroduced next year. And there are other states where this is brewing. I don't believe I've heard anything about Missouri or Kansas on that front. And I would suspect that it's unlikely that, with the sentiments in this part of the country that would happen. But I also didn't think the Corporate Transparency Act would ever be passed into law. And here we are. So I tell you that just so you're aware, there's kind of this whole business transparency zeitgeist that's going on right now. So you need to be aware of that. So I've got a couple things for you to think about. I'm going to throw this back to, I think, Laura, were you the one that was going to give me some questions? Okay.
First of all, thank you so much for all of that information. It just really kind of makes your head hurt, and it's scary for business owners to think about
It does.
Times that really could shut down a business if they miss them and really don't even know that they're supposed to be doing that. So as I mentioned, questions in the chat, there have been several coming in, so we want to get to as many of those as possible. But I do want to kick it off with this question, because some of the information that I have read leads me to believe that even for existing companies, in other words, those that were not started just recently, that they may have triggering events that would cause them to need to file before that January 1, 2025 deadline. Is that true? Can you talk a little bit about that and what a triggering event that might be that would require them to go ahead and file instead of waiting?
Yeah, so this is me just off the top of my head based on this question, didn't think about it before. If you were to terminate an existing business entity in 2024, you would have to file your Corporate Transparency Act filing before you terminate that entity, because after you terminate the entity, no one's going to have authority to do the filing, but you are still obligated as of January 1st to make that filing. It's just not due until January 1st, 2025. And if that filing is not made, the people that had substantial control of that business would be liable for $500 up to $10,000 each for not having made that filing that was required to be made. That's an example. Another example is you're selling your business to someone else and they're buying the equity in the business rather than the assets. That person is going to step into your shoes with regard to Corporate Transparency Act compliance. So they may require you to do your filing before they will take over the reins of the business to do their own filing and update it with their information. Perhaps. I mean, there are other kind of business exigencies that could happen that could trigger the need to file sooner. But it's going to just depend on the facts and circumstances of the people involved. If you have a subsidiary and you're forming a new entity, you have 90 days from when that new entity is formed to file its beneficial ownership report. Well, its beneficial ownership report is going to be determinative based on the parent entity's beneficial ownership information. So you're going to have to figure out what that information is, even if you don't have done your filing yet. So, I mean, those are the types of things that I could, just the top three that pop into my head being asked that question.
Becca, let's go to the chat.
Yeah, so one of the questions that came in was, if a nonprofit has filed for their 501c but haven't received designation yet, should they file?
So my thought on this is as follows. Until you have your 501c, you are not exempt under the 501c exemption. If you can form an entity and get your 501c approved by the IRS within 90 days, then maybe you can avoid filing altogether. That's going to be much harder after January 1st, 2025, because that 90 days is going to become 30 days. And I don't think anybody's going to get it approved in 30 days. So what I think you will have to do is you'll have to make an initial filing. And also, if you have a reporting company that becomes exempt, then within 30 days of that event, you have to file with FinCEN and checks a box that says now exempt.
Okay. Someone else had asked, if someone hasn't filed for 501c status, is there time to file for that status to avoid having to report?
Perhaps. I would suggest that maybe if you can get it done before the end of this year, maybe that precludes you from having, maybe that gives you an exemption, precludes you from having to file. But there's kind of this whole weird timing thing between, you have until January 1st, 2025 to make the filing, but your obligation to make the filing accrued on January 1 of 2024. But your filing is attesting as to information as of the date that you make the filing. So I'm not sure. You probably need to talk to an attorney about that one.
Okay. A question from Tori at Square One.
A different attorney about that one.
There we go.
An attorney you
So-
hire, you need to talk to. Yeah.
Okay, perfect. What is on this filing that is separate from the Secretary of State filing? They've received some questions as to why it's still required when it's already public information.
Well, one, you're filing with the Secretary of State is not a filing with the federal government. Secretaries of State, each Secretary of State has their own thing. So, you know, if you're in Missouri, you form an LLC, you never make any annual filing. You just say what the name of the entity is, registered agent, registered address. In Kansas, you have to report any ownership over 5%. So the information that would be reported in Kansas would be different than the information that's reported to the federal government. And also the 5% isn't tied to the same definition as under the Corporate Transparency Act. It's different information. So
Okay. Yeah.
the filing's gonna be, I mean, you cannot like it, but the filing is still there. You're still gonna have to make it.
Got it. And you may have answered this. Is this an annual filing or just a one-time filing?
It's a one-time filing with amendments required within 30 days of any change event. So there's no periodic aspect of this.
Okay. If someone has multiple businesses, do they need to file more than one FinCEN number?
So the human being will only have one FinCEN number. Each of the businesses will have to file their own beneficial ownership information report, BOIR. You would report that same FinCEN ID on all of those reports if you are a beneficial owner of all of those companies.
Got it. And Cindy wanted to know if the business is in the process of closing and closes before January 1st, 25, does the filing need to be done?
Again, I think you want to hire an attorney for this, but my initial reaction is yes. The obligation to file accrued on January 1st, 2024. So when you do close your business and terminate your business, you do not have to notify FinCEN of that fact. But if you are obligated to make an initial filing, I think that still accrues even if the business has been dissolved before the filing date. But
Right.
there could be some difference of opinion on that.
Right. Okay. A question.
That's why
from
everyone
Kearney.
loves attorneys.
Yeah. Definitely. If you have questions, I feel like the theme is hire an attorney and make sure you get legal help with
Yes.
things. Just to make sure
So
that
what
you're
I've heard from CPAs that I value their opinion and trust their opinion, they said, you know, making the determinations of beneficial ownership interest is a legal issue. They cannot give legal advice. You may be able to find CPAs that will give you that advice, but they technically shouldn't. I guess that's between you and the CPA. There are also third-party providers out there. The top two that I would recommend are FinCENreports.com, and then there's also a group called Single File. I think they do a very good, they understand this, they do a very good job, they have a good, stable offering. You can go get third parties to help you with this. They also are not going to give you legal advice. They're just going to take the information you give them. You're going to say, here are my beneficial owners. They're going to say, great. They're not going to help you figure out who your beneficial owners are.
Okay, and there's another question here. What happens if the business files wrong? Is there liability if someone helps the business file and it's wrong? And the other side of that is there have been some scam pop-up ads offering to file for businesses. So where can people go to get credible help filing?
So I would say you can go to FinCEN's website. That's good information. I would say go to a lawyer and have them help you out if you have any questions. I would not. So like I said, there are some third-party service providers that are good at this, like Single File or FinCEN Reports. You can trust them. But if you just get something in the mail I would not trust that. That
Okay.
is likely going to be a scam.
Okay. And again, what happens if you file wrong? What's the
Okay,
penalty
so
for that?
if you have an incorrect filing, you have 90 days from the filing to correct the filing. That's all they say.
Okay.
So if it's more than 90 days, I would assume you still want to correct it, but it's kind of outside the time that you can correct it. I would just file an amendment and correct it.
Okay.
And
And
yes,
I know
so the human being that hits submit on the information transmission to FinCEN is generally referred to as a company agent. So the company agent, when they hit send, they are going to be certifying that the information that they send is true, correct, and complete. And then I think there may be some other certification language in there, but that they are liable for the truth and veracity of what they submit. They are not responsible necessarily for the information, as long as that they got that information, they have in good faith relied on that information, they should be fine. If there are people who fraudulently provide misinformation or refuse to provide information that's necessary for a filing, so if you have a beneficial owner and they say, well, I'm not going to do that, I'm a sovereign citizen, I'm paid income tax, and I'm not going to start complying with the government now, that person would be in violation of the law. If they're preventing you from making your filing, they would be subject to $500 per day up to $10,000, possibly 2 years of federal prison time. Those people might get some federal prison time. I don't know. But the criteria for having the criminal component is willful misconduct or evasion. But there is personal liability associated with this until the initial report is filed. And then once the initial report is filed, the liability accretes to the business entity, not the individuals.
It is 10 o'clock. I see we have 3 more questions in the chat. Maybe we can just quickly get to those 3 and see if we can answer those before we hop off.
Lightning round.
As a bank, are we going to be required to have CTA documentation as we do for the beneficial owner when opening a new account?
I would say you tell me. I've been asking banks about this and most have not provided a lot of information. I think what is happening is banks are waiting for the final rule on access. And then once they have that, they're going to start rolling out their compliance protocols. But I would suspect that you are going to be gathering this information as well as the other, the other KYC, know your customer information that you collect.
Okay. Janine wanted to know, will this information become public?
That's a great question. So the information that goes into the BOSS system is not public information. The newspaper can't go down and file a Freedom of Information Act request and get this information. The only people that can access the information are the law enforcement bodies that I talked about and the financial institution with their customers' consent. There are very severe penalties for anyone who accesses the information from the BOSS system improperly or uses the information, even if they had proper access, uses the information other than for the reason that they're able to access it. So I think I would have to check, but I believe it was like $100,000 fine and 10 years in prison for people that misappropriate the information. So there are some severe penalties for people that improperly access it, but there is no general public access to this information.
Okay. And Monica wanted to know, for a small law firm, say 3 to 5 attorneys, should all attorneys be listed? Is there a breakdown of the definition of substantial control?
Yes, FinCEN goes into some detail to define substantial control in the final rule that they issued on September 30th, 2022. but I think the short answer is yes. It sounds like all three people in that law firm would need to be disclosed.
Okay, well,
Okay,
there,
and
But check with your attorney, which is probably yourself.
there you go.
I've got an article in the Missouri Bar Journal, and I've got an article in the Kansas Bar Journal. So you can get some more insight from those.
so for those who do still have questions, if it wasn't answered today, or if you think of one later, which very well could happen, Bill has agreed that you could contact him directly. So we're going to send a follow-up email to all of those who registered for this. Again, this program was recorded. We'll have the link to his slides, the link to the recording, and then his contact information so that you can reach out to him directly if you have questions about today's presentation or this Corporate Transparency Act. We'd like to thank Square One and all of the chambers who participated today. Of course, we'd like to give a big thanks to you, Bill, from Polsinelli, for all of the scary information that you provided to us today. And then on behalf of all of the chamber staff members, I want to thank you for engaging with your chamber, because I know that every one of the chambers that's on this call really care about helping your small business be successful. And the only way they can do that is if you engage with them and you communicate with them. So please keep doing that with whatever Chamber of Commerce you happen to be a member of. So everyone have a wonderful day, and I hope you stay warm, and thank you so much for joining us.